Good morning. Thank you for joining us. I'm Ben Fisher. I sometimes start these webinars by saying it'll be nice when we have the opportunity to be back in the same room together as we got to do last year. But actually, today that wouldn't be true as I have a stinking cold. So no one would want to be in the same room as me. So we can all be grateful for virtual technology. Now, today's session is about our consultation, which we launched last November around financial penalties and our approach to financial penalties. Today, we plan to talk through some of the key proposals in there and why we think there's a good case for change. Now, we hope this will help you understand our proposals, but ideally, we'd love you to respond to that consultation, and it's open until the 11th of February. It's really important to understand your views, and we've been talking to a lot of different people around this, both from the public and the profession. But we also want to be able to answer your questions. So if you see below this webinar, there is a link. You can click on that link and you can submit questions live to us about the consultation. You can submit them anonymously and we'll do our best to answer them. But I'm pleased to say I won't be answering them. I'll be asking the questions, and the three people who are going to be answering those are our three panelists. We've got Juliet Oliver, who's our General Counsel here. We've got Jennifer Ackers, who's our Director of Legal Enforcement. And we've got Nabila Zulfiqar, who's our Chief Adjudicator. All three are solicitors and all in various ways both shape and oversee and implement our approach to enforcement here at the SRA. So they'll have some really good insights on this topic. So the way this is going to work is I'm going to have a quick chat with Juliet to talk through some of the headlines from our consultation and what we're proposing. And then I'm going to broaden the discussion out and bring in our other panelists. And again, that'll be the chance that hopefully you can feed in some of your questions. So let's start with you, Juliet. I suppose a good place to begin with is to try and understand our proposals. Could you remind us how our fining powers fit into our wider enforcement work?
Thanks, Ben. Yes. So just to clarify, so fines are something that are available to us to impose internally at the SRA or for the Solicitors Disciplinary Tribunal. They form part of the suite of sanctions that are available following a disciplinary investigation by us against a solicitor or a firm, alongside for more minor breaches, warnings or rebukes, alongside conditions to control behaviour, or for more serious outcomes, suspension from practice or strike off.
And am I right in thinking this isn't about punishment, is it?
No, that's right. They may feel punitive. I understand that. But as with all of our sanctions, the primary purpose is to protect clients and the public by maintaining appropriate standards of conduct and upholding public confidence in regulated legal services. And the particular role that fines can play is to act as a deterrent to future similar misconduct from the respondent themselves or more widely amongst the profession. I think as a financial penalty, they also play a very important role because they can remove any financial benefit from the misconduct, which can help to deter people in the first place if they think there's a risk that it won't be worth it.
And why is the SRA looking at this now?
So our fining regime was introduced almost 10 years ago. So inevitably, while some elements are working well, we think it's time to update it. So we're consulting on a number of areas which we think are important to look at again to make sure we have a framework in place that's modern and robust. So one of the reasons for driving that now is we're aware that there have been a lot of changes in that time in the past 10 years. In particular, as those joining the webinar will no doubt be well aware, in 2019, we introduced our new standards and regulations, and we had a new enforcement strategy which accompanied that. We've seen in the past few years, particularly, a real change in the profile of cases that we handle. We've seen a greater number of cases that relate to ethical behaviour outside of the solicitor-client relationship. So more cases including sexual harassment and sexual misconduct, more cases including offensive and discriminatory communications. There's also been novel and complex issues in areas like anti-money laundering, where there have been a lot of new regulations, investment fraud and things like that. And we're conscious that views about what an appropriate sanction might be are likely to have changed significantly over the years. And contributing to that, we've seen other regulators in the recent years looking at their fining powers and looking at what's needed to provide an effective deterrent, and issuing much larger and often quite headline-grabbing fines as a result. So we think it's really important to go out to consultation again and have a look at what we're doing.
And what are we trying to achieve through this consultation, or what are the benefits?
So we're aiming to, I think, as I said, first and foremost, ensure an effective deterrent from our fining regime to reduce the risk of repeated misconduct. So as I said, that's the key objective for our fines, but also to look at how we can resolve cases much more quickly, potentially reducing cost and delays and stress for all involved. And also, I think importantly, improve the kind of clarity and consistency in the types of outcomes that different conduct will attract. So we've got a few specific proposals, which are sort of briefly in turn. We're looking at, firstly, an increase in the level of fines imposed by us internally as against what should be considered by the Solicitor's Disciplinary Tribunal. We're also looking at reviewing our fining bands and introducing an assessment of turnover for firms or income for individuals in all cases. We're looking at introducing fixed or automatic penalties for certain types of cases. And also reviewing the types of behaviours that may or may not be suitable for a financial penalty.
So I think we're going to cover off all those sort of proposals in a bit more detail. So when it comes to our fining powers, am I right in thinking the SRA has different powers for different types of firms? It's a bit of a complex picture, isn't it?
That's right. So just to clarify, we have powers internally at the SRA to fine solicitors and traditional law firms up to £2,000 only. If we think a case should attract a higher fine or a more serious sanction, we need to make a referral to the SDT, the Solicitor's Disciplinary Tribunal, to achieve that outcome. And the SDT has unlimited fining powers. By contrast, for what we call alternative business structures, which have non-lawyer ownership and control, we can fine a manager or employee up to 50 million and fine the business itself up to 250 million. So the legislation has created an inconsistent approach depending on differences, often quite minor differences in the business structure of the firm. For traditional firms and solicitors, if you look at the kind of current legislative construct where, nonetheless more serious sanctions remain with the SDT, we think in any event that it's time to revive the discussion about the appropriate level for our internal powers to make sure that we can continue to handle the majority of straightforward, less serious cases, and we can really deal with the majority of those in-house and ourselves.
And what would the benefits of that change be? And just remind us of why we've chosen the sort of threshold figure that we've chosen.
That's right. So yes, just to clarify. So as I said, at the moment our powers are to impose fines of up to £2,000. We're consulting on a figure of £25,000. So that's the key change there that people need to be aware of. And as you've in terms of the benefits, to answer your question, as I say, we think that would allow us to deal with the majority of more straightforward, less serious cases, removing the need for the additional time, stress, and cost of a disciplinary tribunal hearing for the cases that attract a fine up to that level. Around 75% of fines by number, looking at the past, I think it's 7 years actually, are £20,000 or less. So that's sort of where we're looking at in the territory of the numbers of fines that get imposed up to that figure. That's £20,000 or less. And our review of recent fines at that level have revealed that most are not what we would consider of a more serious or complex nature. And whilst the largest fines, above £25,000, are generally imposed following a full hearing, the majority of fines up to that level are actually concluded by agreed outcome. We are now concluding around half of all fines, half of all fines imposed by the Solicitor's Disciplinary Tribunal, that is, are concluded by agreed outcome, and the majority of those up to £25,000. What is useful to note is that a hearing is still required in agreed outcome cases at the moment. What happens is we reach an agreement with a solicitor or firm on the facts and the appropriate outcome. but this needs to be approved by the SDT, where the sanction is one which falls in their jurisdiction and not ours.
And I suppose if anyone's listening thinking, what's an agreed outcome? It sort of says what it is on the tin, but it's effectively where we and a respondent agree on sort of that there has been misconduct and what the proposed sanction for be. That is that what an agreed outcome is, just in case someone hasn't heard of that.
That's right. So it's in a case where we referred the matter to the Solicitors Disciplinary Tribunal because the sanction is one which is within their jurisdiction. So at the moment, that would be all fines of over £2,000. But if we and the solicitor or firm can reach agreement on the facts and the breaches that are involved and what the outcome should be, then we would, settle that in a document which sets that all out, and then that needs to be approved by the SDT.
So, in terms of this change, if the SRA, after this consultation, hypothetically does decide that it wants to go ahead with this, can the SRA just do that themselves, or do they need some sort of approval for that?
No, that needs to be made. The change would need to be made by an order under the Solicitors Act. So we would need to take forward any proposals following the consultation to the Ministry of Justice, and they would need to put that into effect.
And if someone is fined by us, is that it? Do they have to accept the fine?
No, they can appeal that to the SDT. There's an appeal to the Solicitors Disciplinary Tribunal for all fining decisions we make, and that would remain.
Now, and I know some people might be worried, and I've heard this before, that the SRA is seeking greater fining powers. Well, are they just looking to, I suppose, bring in more money? Is that a valid concern?
No, because the money that we get in for fines doesn't come to us. All fines are paid over to the Treasury, regardless whether they're imposed by us or by the SDT.
Okay, thanks, Juliet. Let's move on to one of the other sort of big changes that's proposed in there, and that's around fining bans. Could you explain how they work and what are we proposing to change there?
Yes, so this is in our guidance, and this is our guidance that we have in place for all cases, whether we impose a fine ourselves or decide that the case should go to the tribunal. We have guidance which helps us to understand what sort of level that should be pitched at. And what our guidance does is it involves us selecting a relevant band, a sort of fining band, in order to set a basic penalty, and that's based on the nature of the conduct in question. And we can then adjust that basic penalty to remove any financial benefit, as I mentioned earlier, or to take into account mitigating factors. The current bands that we've got in our guidance are fixed up to a maximum of £50,000 for firms with a domestic turnover of up to £2 million. For firms above that threshold, we can calculate the fine as a percentage of turnover up to a maximum of 2.5%. And one of the things we're consulting on is we believe that we should adopt an approach that consistently takes into account turnover across the board. We're also consulting on increasing that maximum to up to 5%. And that's in line, we think, with other regulators. We just set out some details in the consultation document, but many on the webinar will know the ICO is the Information Commissioner is now able to fine up to the higher of 17.5 million or 4% worldwide turnover. That's worldwide turnover. Ours is domestic. And the Financial Conduct Authority can fine a percentage of revenue in bands of up to 20%. So there is a range out there, but what we have at 2.5% at the moment, we think isn't really in line with what others are doing.
No, and also I think it'd probably be right in saying that our £2,000 fine maximum doesn't match necessarily with the fining powers of other regulators either. So that sort of changes on what applies to firms. What about individuals?
Yeah, so we're also consulting on a change which would mean we take into account income for individuals. And that, just in the same way as taking turnover into account, would help us to make sure that fines are proportionate and can really sort of take into account different circumstances. And that's really against a backdrop that sees an increasing divergence in salaries, with profit per equity partner in one firm topping 2 million last year. And, we've seen headlines. We know that take-home salaries for trainees topping £100,000 in some firms, is something that we've been seeing.
But many solicitors they're sort of eye-popping figures, aren't they? And they'll be earning a lot less, particularly some junior solicitors will be right at the other end of the scale.
That's absolutely right. So it cuts both ways. So as I say, we've got this really increasing divergence, and so it allows us to be fair and proportionate in both directions to make sure that what we're imposing is actually, you know, having that is proportionate, but having that deterrent effect in line with the circumstances of the individual.
So although I suppose that proposal is looking at some flexibility, another area where we're looking at changes is around fixed penalties. And I suppose, are there instances where we think it would be appropriate to fine, wouldn't be appropriate, sorry, to fine relative to someone's turnover or income, and maybe just have a fixed penalty?
Yeah, that's right. So this is another new proposal, which would be an exception to that sort of approach where we're taking that flexibility and looking at individual circumstances, and that's where we consider the case would be suitable for an automatic fixed penalty. But we're suggesting that this applies to quite specific cases. It's the kind of cases where there's a failure to comply with administrative requirements in our rules, or non-cooperation with a request from us to do something like provide us with information or a self-declaration, and that these would attract, you know, really fines at the lowest level of around, and we're consulting on these figures, so you know, happy to hear people's views, but a low-level fine of around £800 for a first one-off breach, going up to around £1,500 where we see, you know, further breach. And really that's sort of based on our experience in recent years. We recently imposed a number of fines in this territory for very standardized similar cases of non-compliance with our transparency rules, which prescribe, you know, price and service information to be provided on firms' websites. So where we've seen that, we've issued a number of fines of that nature. And also for people not responding to requests to provide declarations that they have in place an anti-money laundering risk assessment. So once again, not responding to a request for a declaration, and we've issued a series of fines in very much that territory. So under the new proposals, when we see that kind of issue arising, the fine would be imposed automatically. But there would be a warning. So we'd sort of, you know, write out, say, you know, you haven't done X, and then, you know, again, if you don't do X again, you know, you'll get an automatic fine, and there would be a right of review. But the process would be swift and streamlined. There's less administrative burden and cost for all involved.
That's great. And so I'm going to move on to my last question now, before I'd like to bring Jen and Nabila into discussion. And also, I think we've started having some questions come in, so thank you. And we will try and get to some of those. But the last key area we're looking at, sort of, or asking questions or looking at changes around what types of behaviour are appropriate for a fine. And what are we proposing there?
Yes, last but not least, we're consulting on amending our guidance to make a clearer link between the types of behaviour that are and aren't appropriate for a fine. So, you know, it's perhaps more intuitive, for example, to apply financial penalty in cases where there's been financial gain or loss, to understand in those kind of cases what level of fine is or isn't proportionate. So that's sort of one example of how we might sort of describe this. But also, it's worth noting that where a fine is imposed on a solicitor, they remain in practice with no restrictions in place. So this means it won't be appropriate to issue a fine for cases where we need to protect clients or third parties from risk of harm, or where the matter is so serious that the solicitor needs to be suspended or removed from the profession to uphold public confidence. Two areas that we specifically touch on in the consultation, and where we're particularly keen to hear views, are around sexual misconduct and also around discrimination and non-sexual harassment. Both of these were areas that were covered in the Bar Tribunal and Adjudication Service consultation last year, which came to the conclusion that in those kind of cases, these should no longer be able to attract a financial penalty, but rather the sanctions would range from suspension to disbarment. So those are the kinds of areas that we're consulting on, and where we'd really like to hear views.
Thanks, Juliet. So that's a really useful, I suppose, whistle-stop tour. I suppose to summarise, there's 4 key areas we've covered there. Firstly, number 1, increasing the SRA's maximum fine levels for traditional law firms. Secondly, taking turnover or income into account in fines. Thirdly, introducing fixed penalties for sort sort of lesser, more administrative matters. And then fourthly, what we were just talking about there, testing whether areas such as sexual misconduct or discrimination are ever suitable for a fine. And I think the main benefits we've, to quickly summarise that, would be improved consistency in public protections, while also enabling us to resolve cases more quickly, reducing time, stress and costs for all involved, both the sort of solicitor or respondent side as well as for the complainant. So that is a quick summary. But as I said, I'd like to come to Nabila and Jen first, and perhaps I'll come to you first, Nabila. And I've got, I suppose, a question for you, and then we've had a question come in, which I think is on a similar theme. So I wanted to ask about the checks and balances we have in place to ensure the right outcome. But we've had a question, and thank you to who sent this in, about someone else asking, what processes are there in place to ensure that if there are increased powers for the SRA, that sanctions are applied fairly and consistently, and that they finished off with, in essence, who polices the policeman. So Nabila, I'll let you sort of talk through the checks and balances first, and then I'm sure you might pick up some of that, and then Jen and Juliet, you might want to come in on that as well. But yeah, over to you, Nabila.
Okay, thank you. Yes, and thank you for the question. And I hope the 4 points that I make will respond to that question as well. In relation to checks and balances, so for fining powers at the moment, there's delegated authority for adjudication to make decisions in relation to imposing fines. And the first point I'd like to make is that adjudication is functionally separate from the operational teams, so the teams that investigate these cases. So we're independent of the investigation. And what we receive are cases and bundles that are disclosed to the individual. We don't see the whole case file, we only see the documentation and make a decision on the case file that's been disclosed to the regulated person. The second point is that we provide, or are required to provide, written decisions detailing how we've come to our decision. So that will set out, hopefully in a transparent and reasoned and rational way, how we've arrived at the outcome. So that includes making any findings and explaining the rationale for making those findings, and also setting out how we've applied the relevant guidance. The third point is that we also have a right of internal review against any fines that are imposed. So if an individual doesn't agree with either the finding or the sanction, then there is a right of internal review to an adjudication panel. But as Juliet mentioned earlier, there's also an external right of review to the Solicitors Disciplinary Tribunal. So that's another balance or check that's in place. And the fourth point I wanted to make was that we do publish our decisions. So hopefully we achieve consistency and transparency in terms of publication and informing not only the public but also the profession how we've arrived at our decision. So those are the checks and balances that are in place in terms of internally imposing fines.
Thank you, Nabila. That is great. And Jen, perhaps I can come to you. And actually, you might want to pick up this issue of sort of who polices the policeman, but also, I suppose there's a natural worry that prioritising speed, is there a risk that that's at the expense of fair outcomes? What do you think about that?
Yeah, thanks, Ben. And of course, I think that we always need to have the right outcome. That's the priority, and we've got published processes and guidance in place to help us make those decisions. And it's right that we should also be progressing and resolving cases at an appropriate speed. So I don't think really it's about necessarily prioritising one thing over the other, but more about making sure we get the right balance. And the proposals in the consultation will reduce the length of the process involved in securing an outcome of many of those cases that currently go to the tribunal. Listening to the feedback that we've had from solicitors and members of the public, we know that it's important to them to ensure that there's no unnecessary delay. And the cost and pressure of a long drawn out process can be stressful. So the checks and balances that Nabila mentioned are very important, but we could still handle cases quicker. So I think these proposals are all aimed at reducing the burden on individuals, and by burden I mean, you know, the costs, the stress and the length of time between the misconduct and the ultimate sanction. And I think for me, all of those things form part of making sure we have a fairer outcome. So in terms of policing the police, I guess it's about the evidence gathering and making sure that we are only making decisions based on the evidence that's gathered and in line with our sanctions guidance.
Thank you, Jen. That's great. And I actually had another question for you, and this is something, and again, another concern I've heard expressed by some solicitors who say, well, is there a risk that some people might take a higher fine from you just to avoid sort of higher costs further down the line?
Yeah, and I think you know, in reality, I appreciate that there will be lots of factors that respondents take into account when making a decision about when or whether to accept allegations that are put to them. That's entirely within their gift, and it's not anything new. Actually, respondents do that now. What's important to us, though, as I touched on, is that evidence gathering is at the heart of everything we do. And we won't be making decisions unless we can justify the outcome based on the evidence that we've gathered and then set against the guidance that we've issued in terms of sanction and seriousness. And of course, our overarching aim is to achieve an outcome that protects and is in the public interest. So if the respondent will have opportunities to challenge the evidence, argue the facts and mitigate. And this certainly isn't something about plea bargaining over a level of fine. If something isn't fair or right, as Juliet mentioned in her introduction, there are internal rights of review and also ultimately an opportunity to appeal and have their case fully heard at the tribunal. And of course, as Nabila mentioned, we do publish our decision, which is an extra, a further check and balance in the process. But I think, you know, as we've touched on earlier, it's important to remember that we are seeing respondents at the tribunal with that additional stress and time and cost. Simply to have an agreed outcome approved by the tribunal in relation to allegations they accept and may have accepted for some time, but which we don't internally currently have the sentencing options available to us to deal with as quickly as possible. And we see that in the number of agreed outcomes that the tribunal is now making and approving. And of course, I think probably just important to note that not all cases up to that £25,000 limit would be dealt with by the SRA. There will ultimately always be those cases that have to go to the tribunal for other reasons. You know, maybe they're linked in some way to other respondents or other allegations. So I think that's it, Ben.
And that's a good point, isn't it, gentlemen? And as well as that, what we're not talking about is the most serious misconduct, you know, dishonesty or taking, you know, stealing client money or maybe not acting in a client's best interest. Those are the ones that will still be going to the tribunal. Juliet, did you want to come in on that?
Yes, I wanted to just kind of come back on that point, actually, because you know, there is no doubt that the tribunal process adds additional stages and processes. It involves case management, a final hearing, you know, build up of the cost and time taken. And this is what we're talking about. We're saying, you know, that in cases where that's unnecessary, we you know, we want to make sure we can deal with matters in house. But of course, that process is entirely appropriate for serious cases where a full public hearing is required, and we're not suggesting that's not the case. You know, perhaps where complex evidence and legal arguments need to be tested through a hearing process, and you know, those more serious cases, as you've mentioned, Ben. But we are in this consultation really looking at fines in the more straightforward and less serious cases. So if you look at a sort of analysis of some of the fines imposed by the SDT over the past year odd, in that £2,000 to £25,000 pound bracket, there are cases relating to convictions, self-reported accounts rules breaches, failures in client advice, lack of supervision, matters where we've got a lot of sort of admissions, and as Jen said, often where there is an acceptance and an agreement both of the facts and of the breaches and actually of the appropriate outcome. So even when we don't have an agreed outcome, they can be quite straightforward factually and in terms of what we need to do, and we believe it's more proportionate to deal with those through the process that Nabila outlined, our internal finding process. Or where there is agreement, we can do this as early as possible and without that additional need to hold an STT hearing. And it's probably worth mentioning, currently, because those cases where they look like they're going to be a fine of over £2,000 are referred to the STT anyway. We get engaged in that procedure. Agreement might come quite late in the day before the hearing. What we'd be able to do with these cases is discuss and agree the outcome at a far earlier stage and without that additional piece of process.
Thank you, Juliet, and also thank you to Gareth, who sent in. I was just about to send in a question about appeals. I think he sent it in just as Nabila ran through almost the 4-stage process we have in terms of checks and balances. So hopefully we've picked up an answer to that question there. But perhaps I can go back to you, Juliet, on this business around taking income into account. Will that lead to different fines for exactly the same misconduct? And might that end up looking a bit strange, because you could have very big differences on fines for what is the same offence?
Yes, that's right, and I think that is absolutely the logical result of this proposal. But that's because the impact of that fine will be different for different people. So if you think about fines being about a proportionate penalty and a deterrent, to be effective, it must have a real but fair impact on the person who's being penalised. And the impact of the fine will be different for different people, depending on their personal circumstances, depending on their role, their seniority, and their income. So if that's the case, it's hard to see how it's appropriate to fine individuals of significantly different financial resources the same. It doesn't feel fair. And as I said before, with some of the high salaries around and firms of individuals of vastly different wealth, we're looking in this at taking that into account, and we think it's reasonable to do so. We've heard feedback. So if you take a fine of, say, £10,000, we've heard feedback that that's of no real consequence to a partner in a Magic Circle firm to whom it would look, it would look like a sort of, a low level sort of financial impact for them. But as I said, it cuts both ways. On the other hand, that same amount could be very serious for a junior solicitor or a trainee working in a small firm. We think that, this approach, as I said, is reasonable for that reason. And it's also common practice in other settings. We know that the Prudential Regulation Authority does this. It's in the Sentencing Council guidelines that they take this sort of approach. And of course, each case will be assessed on its own merits and its factors. So that's really the rationale behind it. And just as a reminder, the fines don't come into us. They all go to the Treasury unit irrespective.
I mean, it's interesting, Julia. I was actually, we speak to lots of different people about proposals, and I was actually speaking to members of the public yesterday, who all of them instinctively thought it made sense that, a firm that has a way higher turnover compared to a very small firm, or an individual who has huge income, that effectively you might want to shift the level of burden of a fine so it is appropriate to their means. So it is an interesting one. And we've just had a question come in from Lawrence. Thank you for this question, Lawrence. And he said that there's been a lot of publicity recently around significant fines imposed by both the SRA and also people like the FCA around anti-money laundering breaches. And his question is, does this signal a toughening up of approaches in this area, and should firms be worried? Just before I come to someone for an answer on that, obviously anti-money laundering is specifically covered in the consultation, but I would in a sort of cross-promotion way as a communications guy say we have loads of webinars which have tens of thousands of people who've watched them and said they've found them useful on anti-money laundering, and try to make it as simple as possible as to what you need to do to comply there. But yeah, Juliet, Jen, Juliet, I mean, you lead on this area, don't you? Anti-money laundering does really matter to us, doesn't it?
Yeah, I mean, yeah. If I sort of start off on this one, I'm sure that Jen or Nabila might want to come in, but yes, absolutely. I mean, it is a worrying area for firms because the regulations have they were relatively new in the past few years. They've changed, they've iterated a couple of times since then. So there's kind of a lot to get your head around, and we have a lot of resources in place, materials on our website, which if those on this webinar haven't seen those, please do have a look, because we've got a lot of resources and guidance and materials on our website to try and help people understand what they mean in practice, as well as Ben said, webinars and things that we're putting out regularly. And of course, when anything changes, we're putting out communications to try and help people understand that. And with our proactive supervision team in anti-money laundering as well, going out and actually talking to firms and looking at what they're doing in practice and trying to kind of help them understand, those sort of wrinkles on the ground, or how try and share best practice as well, what's working well and what people can adopt. So so I suppose that's all to say, hopefully, although it's an area where there's a lot to get your head around, shouldn't be worried about a significant fine if you're looking at this and you're trying to take steps and you're engaging with us as you should be, and you're looking at the materials we put out. I'm sure that will help you get to a more sort of a place where you can be reassured by what you're doing and what you have in place. But I think it's an interesting area, because as I mentioned at the sort of top of this webinar, one of the things that really has sort of changed for us in the past few years in terms of the kinds of issues that we're seeing and the kinds of complexities of matters that we're seeing, because anti-money laundering issues can of course cut across lots of systems and processes within people's firms. So certainly an area that we're very focused on, and an area that others are very focused on, and of course that the government is very focused on with its consultations and initiatives. What in terms of sort of significant fines, there has been a recent six-figure fine. Interestingly enough, it raises that point that we were talking about before, because that was for an alternative business structure. So that was one that we were able to deal with internally. And those kinds of fines are quite, in that kind of territory, are quite rare for us in the SDT. I think, in fact, if you look at the figures over the last few years, sort of fines over the sort of £60,000 are quite rare for the SDT and for ourselves. If you look at some of the fines that other regulators have been issuing recently, then you are in really a very different territory. And I know that you can't necessarily compare kind of like for like when you're talking about different kinds of breaches and different kinds of businesses, but certainly I mentioned earlier the ICO. I think I was reading recently that in the 2020-21 year, they issued 3 fines for data security breaches, amounting in total to something just shy of £40 million. I know that the Gambling Commission published their statistics for the last year, and I think it was for about 15 businesses, something more like around sort of 30 million. So, in any event, we're just in a completely different territory at the moment with them. One of the reasons why actually what we really want to do is just make sure we're understanding people's views about what they think a deterrent effect really means in practice.
Thank you, Juliet. That was a really interesting answer. And yeah, do look at those resources on anti-money laundering. And I think if one of the big messages as well, I think, is if we find that there are potential issues with processes in one of the firm, or that one of our first priorities is to get a firm back into compliance, because we want to protect the public and remove that risk that anti-money laundering, which actually has such negative consequences in terms of society. It can facilitate drug smugglers and all other sorts of organized crime. The priority is to get them back into compliance. So I've got a couple more questions I think to finish off with. Perhaps if I come to this next one to Nabila, to you, and it's just around the fixed penalties and how do the fixed penalties, how will that fit into our framework? And this is a new thing for us, isn't it, if we decided to go down this route?
Yes, it is very new for us. We don't currently impose financial penalties. We don't have a framework in place or the rules in place, in fact, for imposing financial penalties. Sorry, fixed penalties.
Fixed financial penalties, yes.
Fixed penalties. We do obviously impose financial penalties, and we go through quite a long process for understandable reasons in terms of imposing those, and a notice process as well. What we want to do is ask for people's views on whether fixed penalties would be appropriate in certain types of cases. So over the past couple of years, we've undertaken proactive monitoring of compliance with certain aspects of anti-money laundering we've just been talking about. So ensuring that firms are complying with the anti-money laundering regulations, and also compliance with certain requirements to publish information under the transparency rules. And what we're looking at is whether or not there's a way of imposing these fixed penalties for low-level administrative type breaches, for non-compliance, breaches of our rules, and seeing whether we can operate a more streamlined way of imposing sanctions on firms for these types of actions or inactions. So what we would do, I think Juliet explained earlier, we would have a notification process whereby we would inform the firm that they have breached a rule or not complied with a request to produce information to us, or perhaps they failed to submit an accountant's report, or they haven't complied with certain display information on their website. So we would identify that non-compliance, we would inform the relevant persons at the firm of what action is required, we would give them a chance to put right and to remedy any breach, and if there was no response or a failure, say within a certain deadline to remedy that breach, then we would issue the relevant penalty. We would in fact have a process in place whereby there is the opportunity to review or appeal that fixed penalty, and we're looking at the threshold of around £800 for a first offence, if I can put it like that, and then if there were subsequent offences, looking at increasing that penalty to say £1,500. So part of the consultation is asking for views and feedback as to whether or not that would work. We know that it works with other regulators, and there are examples in the consultation about other regulators who apply this kind of fixed penalty regime. And again, it's part of our armory, part of our tools that we think would help to streamline and make our sanctions process more efficient and more effective.
Thank you, Nabila. And I've got one, I think we've got time for one more question, and it's an area which, if anyone's been looking at the media over the last few years, will have seen a lot of coverage, and it was on the approach to penalties for sexual misconduct. And Jen, this is an area you're familiar with in terms of your work in legal and enforcement. What's our thinking behind our proposals there? Oh, you're on mute, Jen, just if you come off that. We've done well to get through 43 minutes without one of those.
Didn't I?
Yeah, that's all right. It shows it's live.
Okay, this is an important area for us, and as a legal regulator, we want our outcomes to reflect what we're trying to achieve in terms of public confidence and protection issues. And I know there's been some debate on what we should be involved in as a regulator in terms of professional and private life. This isn't necessarily just reflecting public opinion, though. It's about thinking about those public protection and confidence issues. So when we see allegations of sexual or other, as Juliet said, other discriminatory conduct proven, it's important to understand, what exactly does command public confidence in terms of an appropriate outcome. And the kinds of cases we're seeing are serious and involve real harm to individuals and risk to colleagues or others. And we really need to take that seriously. Our provisional view is that financial penalties for this kind of behaviour just doesn't feel right. It's hard to quantify what level of fine would be appropriate for a particular behaviour, and when this isn't a civil case with, compensation and redress. And so I think for the fact of financial penalties for this kind of behaviour has actually been surprising to many. So in summary, I think for us, it's about, what best upholds public confidence in the work we are doing. It's a genuine question. Other regulators, as Juliet mentioned, are grappling with these issues at the same time. So it's right that we ask the question now. But we appreciate there will be a range of views and opinions on this tricky subject.
No, absolutely, Jen, and that to echo that, and on all these topics, there'll be a range of views, and that is one where definitely I've heard a range of views. But that's why we're consulting on this, and I just reiterate, it'd be great if you could respond to the consultation. I think we've come to the end of our questions. Thank you for everyone who sent one in. We've got no more to answer. We hope you found this webinar useful, but I think it was useful, but that doesn't really matter. We want to know what you think. So there is a link to feedback below. You can tell us whether it was good, whether it was fine, or whether we deserve a fine, given the theme of the webinar. And I'll stop the puns there. You can definitely feedback on whether you think this has been useful, but also please be kind to Nabila, Juliet, and Jen, who are all lovely. You can be as brutal as you like with me. My 4-year-old told me I was a horrible man this morning for not giving him extra porridge, so you can feed that in there. But as I say, we'd love to get your feedback on the webinar. We'd love to get your feedback on the consultation. You've got to the 11th of February to do that, but otherwise, thank you for joining us. This webinar will be available on catch up, so if you want to watch back on our YouTube channel, you can, or you can share it with other people. But otherwise, I hope you have a good Friday and a really good weekend.